Irish company law's interaction with striking off, dissolution, and restoration of companies in Irish law. Legislation surrounding strike-offs enjoy statutory footing per the Companies Act 2014. Involuntary strike-offs are sought under Section 726 of the Companies Act. Such involuntary strike-offs may occur where there was a failure to file annual returns, or there has been a notification of failure to deliver under Section 882 of the Taxes Consolidation Act 1997 by the Revenue Commissioners. Per Section 727, the Company Registry Office must notify a company at risk of striking off to allow rectification and regularisation of the matter. Failing rectification to the satisfaction of the registrar of the CRO may strike off the company. A voluntary strike-off occurs where the company ceases to trade and there are no outstanding liabilities. This is achieved by a resolution of the company and its subsequent filing with the Company Registrations Office. Case law concerning dissolution includes Gautier and the Registrar of Companies in 2013 as heard in the Irish High Court. This case underscores limitations of judicial review in challenging administrative decisions concerning company dissolution, particularly when statutory requirements by the company have not indeed been met, and therefore the filing of company returns are the safest way to ensure that the company is not itself at risk of being dissolved or face dissolution, as reversing the process is burdensome and may prove difficult for companies who have not been in full compliance with legislation regarding filings for the Companies Act. In the Blenheim Leisure case of 2000, the common law held that courts are empowered with authority to impose conditions on restoration of a company, and may direct that such conditions shall not serve as means to enable third parties to gain undue benefit, and therefore any terms and conditions that a court may prescribe shall be equitable and just, and shall not give unfair advantage to a particular class, such as that of creditors, such as that of directors, or such as that of the members in question. And therefore, the courts will be very wise to the fact that perhaps while creditors may enjoy standing to ensure that a company does not face dissolution, or may in fact does face dissolution should they be secured so as to leverage their security, the courts will be wise to make sure that no conditions are issued by the courts that give advantage to such third parties unduly. Legislation concerning restoration of companies once struck off is again available in the Companies Act 2014. An administrative restoration is possible when the strike-off is recent, and the company need merely reapply to the Company Registration Office as it would setting up a regular company without prejudice. A court order is available where Section 738 is activated and invoked, where the applicant is disadvantaged by the dissolution of the company, and it has been filed within 20 years of the dissolution. Such an order shall be granted by the courts where it is equitable and just. As stated previously, creditors, former members, and officers enjoy standing to be able to file such court orders under Section 738 on the basis that they have been disadvantaged, and therefore the order ought to be granted for restoration of the company so as to disadvantage them. Local standing is given to former members specifically in Section 738, subsection 2c of the 2014 Companies Act. Case law concerning restoration include the Nalto construction case, as heard in the Irish High Court, that restoration shall be made where it is just and equitable to do so, and that the courts shall be guided by just a sense of justice and equity in decisions to restore or not, as the case may be. In Amantis Enterprises, the High Court of Ireland in 1999 directed that the criteria for restoration include focusing on necessity to demonstrate legitimate interest and the just and equitable standard of that company existing or not, as the case may be. In the Barland case, 2004, the Irish courts considered the complexities of a restoration order after a significant lapse of time, and where property had therefore been, in the intervening periods, dissolved and vested in the state by the appropriate legislation. That legislation is the State Property Act, where Section 38 addresses that the vesting of the property of a dissolved company resides in the state, specifically under the jurisdiction of the Minister of Finance, Public Expenditure, and in the most recent government, the Minister of Public Expenditure and the National Development Plan. If a company is dissolved, its property becomes the state property, unless disposed of prior to dissolution. And therefore, if a company is facing dissolution, it may be advantageous for the company to dissolve and dispatch property in the ordinary sale of the company's assets prior to its dissolution so that it does not fall behind to the hands of the state, so that there is an appropriate price sought for the property in the interest of the company. It really does befall on companies to ensure that they file returns appropriately if they do not wish to fall foul of an involuntary strike off as a company and therefore enter the complexity of the State Property Act. So due with companies, if there is a significant lapse of time, it may be difficult to recover that property from the state under the State Property Act and in the courts per Barrowland, given that the state may have now have a vested interest in the usage of that property, as after a significant period of time, the state may indeed see a fine property and consider it suitable for some public service use, and therefore complexities arise. Additional resources need to be pumped into it by the company seeking restoration, and may indeed cause the company a significant and unexpected surprise in terms of costs. And therefore, it is possibly advisable, if restoration is foreseen, that and a company might see this when they're entering a dissolution stage, that they may indeed wish to dispel of the property and dispense of it prior to the actual declaration of dissolution by the courts or the company registration office as appropriate to the circumstances of the case.